This is Austin Smallwood, your SCR Director of Legal and Regulatory Affairs, to walk through the upcoming forms change that will be taking effect on June 13th of 2022. SCR will be going to a strict due diligence contract in regards to repairs. This is going to be a brief introductory video of where exactly that will be in the contract and how to fill out the due diligence portion of the contract. But if you're looking for additional education, some explanation of why the forms change was made, as well as going through some of the more common issues we see with due diligence and how to potentially remedy those, I would encourage you to do one of three things. Give us a call on the hotline and we can certainly walk you through any due diligence questions you may have. Secondly, contact your local board. I will be doing training at every local board, so call your AE and figure out exactly when I will be showing up, and I'll be more than happy to answer any questions you have at that time. Or third, we will be doing a webinar. They'll be going more in depth on this forms change on April 28th, so I would encourage you to attend that as well. So this forms change is in paragraph 8. I do want to note we did not add any new verbiage to the contract with this change. We simply deleted. So previously you had 3 repair options. In paragraph 8 you had repair procedure, due diligence, and as is. We simply removed the repair procedure and the as is portions of the contract. This due diligence language here is the exact same due diligence language that has been in the contract for many years. But I did want to walk through briefly how to use this section in case you are not familiar with it. So due diligence is one date. There's one deadline. So as opposed to a repair procedure where there were a number of dates that you had to keep in mind, due diligence has one deadline, and it's an all-in deadline. So within that deadline, the buyer needs to conduct and obtain any inspections that they would like, send any repair requests that they have, negotiate for those repairs with the seller, and then either, based on what the seller says, agree, the parties come to terms and they move forward. They need to agree to extend the due diligence period, or the buyer needs to terminate, and we'll get into how to properly terminate. Failure to do any of those will result in an as-is contract in regards to repairs at 601 on the date that is listed here. Please do put a hard date here. Do not write in calendar days or business days. This is intended to be a hard date. That leaves no room for interpretation. Everyone understands what a hard date means. So as mentioned, during the due diligence period, the buyer can do any inspections that they would like, and they can send in, and they need to send those requests to the seller. The proper form for sending those repair requests is going to be our repair request form, SCR form 525. The seller can then review those repair requests and determine whether or not which ones they wish to make and whether or not they wish to make them. The buyer then, if the seller refuses to make repairs, can determine whether or not they still wish to buy the house anyway, wish to negotiate for some additional repairs or other repairs, or the buyer can terminate the contract. So, to terminate the contract, the buyer needs to do 2 things. They need to deliver to the seller prior to this deadline that's listed in this first sentence a notice of termination form, which is SCR form 313, and the termination fee that is listed in this contract here. This for termination fee can be any number, and that is something that's negotiated between the parties. But the buyer does need to turn both the notice of termination form and the termination fee to the seller by this deadline. Failure to do that will result in an as-is contract in regards to repairs, and if the buyer then decides that they wish to walk away from the contract, they need to talk to their attorney to be aware of their legal risk in doing so. Now, if the buyer decides during this time period or any time of the contract that they are having to terminate because of financing, appraisal, or termites, that would not apply. The termination fee would not apply. That termination fee is only for a buyer who terminates during the due diligence period for due diligence reasons. This termination fee is a fee that is only paid upon termination. This is not a fee that's collected up front. This is a fee that is separate and apart from earnest money and should not in any way, shape, or form be commingled with earnest money, cut out from earnest money. It should be completely separate from earnest money. This termination fee is paid directly to the seller. Now, if a buyer does wish to terminate, we would encourage them to, at the same time, they do have to send the notice of termination, 313, and the termination fee to validly terminate under due diligence. But I would encourage you at the same time to send SCR 518 a release form, since that will be able to handle earnest money. Earnest money, there is no automatic right to earnest money by either party under due diligence. That is still the same answer as you will hear on the hotline: mutual agreement parties or a court order. But the way to get that mutual agreement is through that release document, Form 518. So the key for this due diligence section is to make sure that you know when your deadline is, that as a buyer, you've given yourself plenty of time to do any inspections that you wish, adequate time to give that request to the seller, given the seller adequate time to be able to review your request, and you get any bids that they may need, figure out what those repairs are going to cost for them, and then also give yourself some time on the back end to negotiate. This 6 p.m. on a hard date is not the deadline for the buyer to deliver those repair requests. That is the deadline that everything needs to be wrapped up and done. If the parties can't reach this deadline and know that in advance, then I do encourage you to try to get an extension. Doing a pen and ink change on the contract, just scratch out the date you put here, have both parties initial and date with the new date that y'all have all agreed to. If you have any additional questions, like I said, please do give us a call on the hotline, attend one of our classes, or certainly our webinar. But this change again will be taking effect on June 13th. This is Austin Smallwood, your SCR Director of Legal and Regulatory Affairs.